Good morning.
Still good morning. Good morning.
Mark Ronzato on behalf of the plaintiff appellant. To the extent there are any self-imposed limitations on the asking of questions, I waive that limitation. Okay. I'm here today on the smaller of the two no-fault cases that this court is confronting this morning. But it is still a significant question regarding the exception to the one-year rule, 3145-1. What's most interesting about this case, most notable about this case, is I have a statute. The statute says the written notice as provided herein, the final sentence of that statute, does in fact describe what has to be contained in the written notice. And what's also kind of amazing about this case is that everybody who's relevant to this particular piece of litigation has agreed throughout that the information that the defendant received complies completely with the last sentence of 3145-1. So we have a situation in which the statute requires as provided herein, and it describes what must be in the notice, and the circuit court, the Court of Appeals, the defendant, and the plaintiff all agree that what's required in the last sentence of 3145-1 has been complied with. So the difference between the parties in this case can be summarized with one sentence, the most significant sentence, in my opinion, from the Court of Appeals opinion, which read as follows: the medical bills and medical records, speaking of the stuff that was sent by the Nebraska Medical Center, although sufficient in content, did not fulfill the purposes of the statute. Now, what that one sentence presents is rather starkly is a distinction between the text of a statute and the purpose of the statute. And I am stunned in shocked to be in late 2016 before this court debating the question of whether the purpose of the statute or the text of the statute controls. And
let me think. You think the text does?
I'm fortunately on the side of the text in this particular case. And in that respect, I feel very comfortable standing up here. But I obviously don't need to belabor this court's
okay. Well, let's turn
16 years.
Let's turn to, okay. I'm a textualist.
Well, here's what I'd like you to.
We see what you did there,
in thinking about this case and trying to make this case a little interesting, here's the way I think you should read the Court of Appeals opinion. 3 judges of the Michigan Court of Appeals entered the Court of Appeals' own little time machine, and they went back to early 1980, and they found 5 Michigan Court of Appeals cases that talked about substantial compliance with 3145, a substantial compliance concept built on the foundation that the purpose of the statute was more important than the text of the statute. And the ultimate of those 5 Court of Appeals cases from the early 1980s was the Heikkinen case, which was in essence followed in this particular case by the Court of Appeals, because the Heikkinen case found that the notice in that case complied with 3145-1, but it didn't serve the purpose of 3145-1. And that's the case that followed by the Court of Appeals in this particular situation.
Must have been fun to practice law in those days. Can you, I mean, like, how do I satisfy the text and the purpose? What do you make, though, of the defendant's argument that the 4th sentence of 3145 imposes some obligation? What do you make of the 4th sentence that?
Well, the 4th sentence, the notice of injury required
by a person claiming to be entitled to benefits, therefore, or by someone on his behalf. Does that?
Well, the fact is that unless the prior case gets overruled, there's no question that at the time this was sent.
Okay. Do you need the covenant to be affirmed in order?
Oh dear no. Oh dear no.
Let's make
because it was a person.
Let's leave covenant out of it for the moment.
Yes.
So I can hear your pure textual argument about what work is done by the requirement that the notice be given by a person claiming to be entitled to benefits or by someone on his behalf.
Yes.
As I understand it, your client was not the agent of the insured. They were just seeking to get payment. Were they functioning as an agent in filing this notice?
Well,
or were
they were,
functioning
they
to
were,
receive?
they were a provider.
Okay, they were sending their bill.
That's correct.
Okay. Now, I don't understand why they are a person claiming to be entitled to the benefits for, or someone in the insured's behalf.
Well, I have thought since Lakeland and Covenant, in all of these cases, these providers are claiming on behalf.
I understand. I want you to make the argument without reliance on Covenant.
Well, why would I make the argument without Covenant? Because the fact is that the law existed at the time of Nebraska.
That's your argument.
Well, also,
you wish. I suggest to you that I would like you to make it the way I suggest, but you don't have to.
Well, the fact is that
let me put it this way. Okay. If the insured has no independent cause of action under the No Fault Act, what's your argument?
Well, the argument is that even without an independent right,
yes,
they have no right. They are still making a claim. They're making a claim on behalf of that person. That's what they're doing. They provided services. They are making a claim. Whether they have the right to recover, they certainly had the right to recover it at the time this notice was sent under the law that existed in the Court of Appeals. Whether they have the right, and quite frankly, Nebraska Medical Center is presumably not going to recover in this case because of the one-year back rule, okay, no matter what else happens. But the fact is they were making the claim on behalf of this person. He's identified it. You know, in terms of statutory interpretation, it's kind of interesting to me that the final sentence of this does, in fact, distinguish between the claimant and the party injured in terms of what you've been arguing for the last hour. The fact is that this last sentence specifically distinguishes between the claimant, that's the Nebraska Medical Center, and the injured party. So this statute does, in fact, draw a distinction between the claimant and the injured party. And Nebraska Center was, in fact, a claimant under this statute.
Okay.
Make sure you bill Mr. Hillary for that one.
I'm sorry?
Make sure you bill Mr. Hillary for that one.
Yes. You're welcome. I'll mention it to him.
Justice Young, members of the court, my name is James O'Brien, and I'm here on behalf of Zurich American Insurance Company. It's very rare in my practice that I have the privilege to address this court. It's also very rare that I get a bad cold, so this is an unusual day for me.
Don't share.
And I'll wipe the microphone when I'm done. I may ask that a question or two be repeated. Our position is quite simple. We think that the Court of Appeals and the trial court got it right in this case, and that we're in perfect agreement with the appellant that strict construction of this statute was what was intended by the Court of Appeals when they issued their opinion. They were looking at the complete statute rather than focusing strictly on the last sentence. We read that the requirement that this notice be by a person claiming to be entitled to benefits therefore, or someone on its behalf, has a meaning. It's not just ornamental. The meaning that's been applied to that by the cases that have construed it, including this one, are that there must be something in that notice that gives an intent, that makes clear, makes explicit an intent to make claim for personal injury protection benefits. And in this case, it really does make a difference. And that's why I think this may not be the best vehicle if this court is looking for a way to update the proper interpretation of 3145. Sorry.
Let me just suggest to you that we've been for a very long time saying If there's a purpose for a statute, we look to the language the legislature used to ascertain that purpose. It's there and not in the ether. It strikes me that the Court of Appeals opinion in this very case and a number of cases that inconsistently relied on purpose that was drawn not from the text but some other policy have violated this approach to discerning legislative intent. They say, well, the actual notice requirements stated in the last sentence are there, but the purpose isn't decided, isn't served by that. I don't know where that purpose comes from. And I want you to point to me with the words here and show me what purpose is not served when you actually provide the information that the last sentence requires.
It comes from the penultimate sentence, from the second last. And it's unfortunate that the Court of Appeals used that sentence, which they quoted from the Heikkinen case, as sort of a closing to their opinion. Earlier in the opinion on page 7, they have an extensive quote where the Heikkinen court makes it clear and where this court makes it clear that what they are talking about when they say the purpose is that you have the specific contents, name, time, nature of injury, name of the person, and you have the purpose of that notice, which is that you give notice that you are a person, or in this case, a hospital claiming on behalf of a person who claims to be entitled to no-fault personal injury protection benefits. There was...
I don't see that purpose that spelled out that way. I see that the notice of the injury required may be given by the insured or his agents by a person claiming to be entitled to benefits or by someone on his behalf. Now, I don't see anything that requires them to say, I'm making a claim under the No Fault Act. Do you see that in here?
I do. I can't read it any other way. Claiming to be entitled to benefits, personal injury protection benefits, therefore, that is for the injury.
Entitled for benefits. Okay. Okay. Anything else? On the what leads me to understand that the legislature required, not that it was just a good idea, required something more than the specific information in the last sentence be provided, and that be provided either by the insured or the insured's authorized agents, because the insured is a person claiming to be entitled to benefits.
With respect, I believe that it's not descriptive, it's prescriptive. In other words, it doesn't just describe the person who is making this claim. It is a requirement of the claim itself that it be a claim. In this case, we have the extreme example where medical records with no explanation at all came. Now, those were identical to the same set of records that were produced before we were added to the case as a response to a discovery request. So they were no different than that. We pointed out that it would be the same type of package with no explanation,
let me ask this question.
Purpose given.
It strikes me that the provider sent a bill, right, to the insurance company. That was what this was. What initiated it was a bill for services provided. That was not made on behalf of the insured. That was made on behalf of the provider, was it not?
It was.
And it was made without authorization of the injured person, the insured.
Also correct.
So my question then is, how does that notice comply with what you've described as the penultimate sentence?
It does not, but I was focusing on a different area of noncompliance.
What was that?
I think we're saying the same thing in different terms. It's not on behalf of the person entitled to the benefits, but it doesn't say that it is a demand for payment, a claim based on the No-Fault Act. Nebraska is not a no-fault state. There's nothing
wait a minute.
Sorry.
I'm trying to understand what has to be done. If the provider here had the permission of the insured to send this bill, why wouldn't that have satisfied every requirement of this statute?
Explicit permission?
Yeah.
Did not have that. All right, if he had it.
Yeah.
It's, again, here's the difference that I'm getting at. That would give him the person, that would satisfy that it's someone on his behalf, but it would not satisfy.
Who's a person claiming entitlement to benefits, right?
No one was claiming to be entitled to benefits. That was not expressed in sending medical records.
How do you construe that? Tell me the simplest way that a person claiming to be entitled to benefits, therefore, should express that.
This is a claim for no-fault personal injury protection benefits.
So you have
I could make it shorter than that.
Wait a minute. So in order to satisfy this provision that we've been talking about, you have to use the magic words, I'm applying for no-fault benefits.
No magic words. Any expression that says, yes, you do have to say personal injury protection benefits, yes.
The provider says here, we are submitting this bill for medical services provided with the authorization of the insured. Would that have satisfied the requirement?
No.
What's missing?
And I have to explain the context of this case, if I may, just briefly. This was in 2009, before the Bessick versus Citizens Mutual case. No one believed, Mr. Perkovic didn't believe, Judge Sapala, the trial court, didn't believe, no one believed that the insurer for E.L. Hollingsworth, which had no contractual relationship with Mr. Perkovic, was the no-fault insurer for Mr. Perkovic. So, sending medical bills to a company that has no relation to Mr. Perkovic does not put him on notice and does not satisfy the requirements of the statute.
I can understand why the insurer couldn't quite sort this out, because it wasn't a direct relationship. My problem is the legislature didn't seem to anticipate that, and I don't understand how you're pouring that into this language.
I'm honestly missing something here. If the
am I.
notice is by a person claiming to be entitled to the benefits, now that is a requirement, that he state that he is a person claiming to be entitled to the benefits.
And that's what I was trying to say. The same notice, except the provider says we are authorized to make this claim for payment of benefits by this person. Is that?
And benefits is understood to mean no-fault benefits?
I'm just telling you what I think. I'm trying to understand whether that's sufficient under this. No more than that.
That would be a different case, but that would be marginally sufficient if it was under circumstances that made it clear that what was meant by benefits was no fault.
It doesn't say that.
Well, I know, because this is in the no-fault statute. They don't keep saying it over and over again.
Okay.
But for a Nebraska hospital, that is an important element of the claim.
Okay, understood.
Or a message from a Nebraska hospital, excuse me.
Okay. Anything else?
I think that's it.
Thank you. Anything else?
This notice came with a designation of the policy number. The policy happens to be something that contains no-fault coverage. That's something I indicated. That's Exhibit F to my supplemental brief. So you have a claim made by a provider to Michigan company that sells no-fault benefits that says we provided medical care to this injured person, and here's your policy number. Even if the Court of Appeals was correct in what they required here, it's still there. The information is there.
I think the content probably satisfies, at least as I parse it, the requirement. The question is whether it was submitted by a person authorized.
Well, it's interesting because this is a newer issue in this case, because it was always on the question of the ultimate sentence of 3145-1. But the penultimate sentence doesn't make any difference, because all that says is who it has to go to and who has to provide it. And it only says a person claiming on behalf. And they were certainly claiming they had provided insurance, they had provided medical care to somebody.
But they don't have a claim, unless leaving covenant out.
But it doesn't say successfully claiming, it says claiming. And the fact is that no matter how you parse this, you're going to have to add some words to this in order to come up with an argument that makes them a winner in this case. That's what the Court of Appeals did. They added stuff to the last sentence. The fact is, this was an entity, a provider, claiming on his behalf. Whether they have the right pre or post covenant is irrelevant. They were claiming. That's all that this requires.
They're claiming to be entitled to benefits.
They're claiming benefits. They provided medical care. Now, when I tell a Michigan insurance company that provides no-fault coverage that I'm requesting reimbursement for medical care provided to somebody who's been involved in an accident, how hard does a Michigan no-fault insurance company have to think in order to come to the conclusion that they may be asking for something covered by the No-Fault Act?
Okay.
If we, depending on how the covenant case comes out, if we did some work on some of these cases, like the Lakeland case, does that impact whether a Nebraska or other out-of-state medical provider could be considered a person claiming to be entitled to benefits or not? Or are you saying they could be flat out wrong?
They can be flat out wrong. They can be flat out wrong. Okay? They could have been wrong back at that point. I don't think they were, quite frankly. I can't say I'm an expert on the Lakeland covenant issue here. But the fact is, it only says claiming. It doesn't say successfully claiming.
Does not also the word may in the penultimate sentence help your cause?
Well, it's interesting, because I certainly read that as the part of the first one as to who they could give it to.
Right. There's notice mentioned up front, written notice of the injury is required. And then the second from the last sentence says it may be given to the insurer by anyone authorized, agents, persons claiming to be entitled. And the last sentence tells us what shall be in there.
That's correct. The last sentence is the content, and it is in mandatory language, obviously.
So while it may be given in this way,
that's correct.
If a notice has that,
you're correct.
You rarely say that.
I adopt what you say.
Okay. Thank you. The case is submitted.